Coming up on Philosophy Talk.
Everything the Founding Fathers thought in the 1780s when they wrote that Constitution, they learned themselves in the 1790s was wrong.
The judiciary in a democracy.
All presidents from the beginning have always taken, politics and the likely views of the judges into account before putting them on the bench.
What is the role of an unelected judiciary in a democracy?
When they wrote the Constitution, no one was yet thinking about the judiciary as an important interpreter of the Constitution at all.
How do we hold unelected judges democratically accountable?
The way judicial power expands relative to the political branches is the more we come to think that the Constitution is just ordinary law. Then, of course, you have to have lawyers and judges interpreting it.
Our guest is Larry Kramer, Dean of the Stanford Law School.
It's a bizarre idea to say we're a democracy, and here's the most important part of our law, and it's so important that we can't let the people have anything to do with it.
The judiciary in a democracy.
Coming up on Philosophy Talk.
After the news.
Welcome to Philosophy Talk, the program that questions everything.
Except your intelligence. I'm John Perry.
And I'm Ken Taylor. We're coming to you from the studios of 91.7 KALW, local and innovative public radio for San Francisco.
Continuing conversations that begin at Philosopher's Corner on the Stanford campus and in various bars and bistros in the Palo Alto area.
And from those lovely locales, we migrate or stumble sometimes to the air via the signals of this lovely station, and then from the air to the internet via our blog, the blog.philosophytalk.org. And I've got the conversation started with a searching, questioning blog about our topic today, the judiciary and democracy. What's the philosophical issues here, John?
Well, to keep it philosophical, Ken, we might think of it this way. Suppose you and I are the committee to form the social contract.
We're in trouble.
The original from-scratch charter that's going to set up a state. Now, what would lead us to want an independent judiciary as part of the social contract?
I'm taking for granted that we're talking a democracy here. I mean, I love democracy, and I can't imagine wanting to live in anything else. But taking that for granted, I think this is a little tricky. I think this is tricky. The judiciary, I see why we want that. We want somebody to settle cases in courts of law and to apply the law and interpret it fairly without an agenda. And there's a certain kind of independence you want there. But when we're talking about like judicial review, saying what the law is and enforcing that interpretation on the people, I'm not so sure why we would want, in a democracy where power is supposed to rest with the people, these unelected persons telling us how we're going to live, in a way. Why should we want that?
Okay, I mean, I'll go along with the democracy part, but that's not all there is to it. I mean, our social contract was really influenced a lot by John Locke, and if you read his work on liberty, he's not all that, the second treatise on government, he's not all that consumed with democracies. He's interested in protection of people from tyranny. The tyranny of a single person, which was probably what he mainly had in mind, but it equally applies to the majority. You have to be able to live your life without thinking that the whims of a single person or the majority are going to change the rules in the middle and drag you off to jail.
Right, and so you don't want the judiciary just to be answerable to the whims of the majority. That's what the Lockean your thought is there. But wait a minute, though. Here's the problem. You want to insulate the judiciary from politics. I think that's a good impulse. But its decisions have great political reach, right? And sometimes, and think about this, when the death penalty cases, desegregation, all this stuff that the courts have decided over the years have gone against the will of vast numbers of people. And they haven't just said, oh, well, we lose. They wanted to seize the political process and take over and undo what the court did. And that caused great turmoil. So insulate them from politics, but then let them shake up politics and then not be answerable? You think that's a good idea?
I think in our social contract, we're going to want to design a system so that we get, at least for our Supreme Court, some very wise individuals who are really dedicated to the rule of law and good at interpreting the law, but have one ear, at least part of the time, to the political reality, so that we don't just have what you're describing.
That sounds like a pretty delicate balance. And to help to see if we're succeeding in striking that balance, a roving philosophical reporter, Zoe Corneli, went into the courtroom, and she files this report.
Ladies and gentlemen, please rise and come to order. Court is now in session.
It's a typical Wednesday morning for San Mateo County Judge Craig Parsons.
Good morning, ladies and gentlemen.
Trial judges like Parsons hear cases at the county level, and in California, they're chosen by the voters. But appellate and state Supreme Court justices are appointed by the governor.
And there, judges are called upon to decide constitutional questions where there isn't an obvious right or wrong answer.
Roger Warren is a scholar in residence at the Judicial Council of California.
And it's difficult for a voter who's not legally trained, especially, to have a way of really evaluating whether the justice's interpretation of the law is right or wrong.
But voters do get to decide whether to keep higher court judges when their term is over. That's called a retention election. So how did the United States end up with a system that mixes judicial elections and judicial appointments?
The original 13 states provided that all of their judges would be appointed because they thought that was the best way to establish the independence of the court system so that they would not be subject to the will of the people.
By the time of the Civil War, Warren says, new states were electing their judges.
And the original reason for that was that people had grown very distrustful of judges because they were appointed as part of political processes in the governor's offices and in the legislature. And the idea was to free judges up from any political involvement by electing them. Then what happened is that the same political influences ended up dominating the election of judges also.
Voters can have a powerful influence on the judiciary. Back in 1986, the electorate changed the face of the California Supreme Court. 3 justices, Rose Bird, Cruz Reynoso, and Joseph Grodin, were up for retention. They were under pressure from voters to be stronger on the death penalty. Grodin says at the time he was deliberating on a murder case.
And I remember thinking to myself, well, now, if I vote to affirm the death penalty in this case, people are going to say Grodin is only doing that because he wants to stay on the court. On the other hand, if I voted to reverse the death penalty, I would be acting contrary to what I thought was appropriate in the case.
Former Justice Grodin says he was acutely aware of public opinion.
I had to make a conscious effort to put that aside and not consider it, I have to say that I don't know of any occasion when I was on the Supreme Court or the Court of Appeal when I heard any judge suggest that a case should be decided in a particular way because of the popular reaction to the case. That does not mean that it wasn't on the mind of particular judges, but everybody understood that our obligation as judges required us, so far as we were able, to disregard such influences.
Bill Hing, a law professor at UC Davis, says that kind of pressure threatens the independence of the state's judiciary.
Placing judges on a ballot automatically makes it a political decision on the part of voters. What happens is that a voter cares about particular issues, such as the death penalty or abortion, instead of, is this judge fair? Does the judge weigh both sides of the argument?
So, is it better to subject judges to the whims of the majority or the politics of elected officials? For Philosophy Talk, I'm Zoe Corneli.
Thanks, Zoe, and thanks to Bea La'o, who also contributed to that report. I'm John Perry, and with me is Ken Taylor.
And our guest today is Larry Kramer. He's the Richard E. Lang Professor of Law and also Dean of the Stanford Law School. He's author of The People Themselves, Popular Constitutionalism and Judicial Review. Larry, welcome to Philosophy Talk.
Thanks. Good to be here.
Larry, the idea of an independent judiciary, at first blush, sounds pretty good. But on second blush, Ken and I, in our little social contract pretense, weren't so sure. Unelected often means unaccountable. And in a democracy, power is supposed to rest with the people. So isn't the very idea of an unelected, unaccountable judiciary incompatible with democracy?
Well, democracy as a concept is probably broad enough to include some institutions that are more or less accountable. But yeah, you want to find a balance here between, on the one hand, independence and on the other hand, accountability. And if you have too much or too little of either one, you're going to get, things are going to go off a little.
So are there some principles that we can use to think about whether we've got the right balance? I mean, saying we want a balance, I want to know, well, how do we adjudicate whether we've got the right balance?
I don't
what
think
favors in one, and what conditions favor one.
I don't think there's not some objective standard out there that you can look to. I mean, it's really a question of experience, looking at what other countries do and have done, looking at what we've done over time, and there's a whole lot of examples out there to look at.
So, give me some historical perspective and some comparative insight.
Sure.
How have we decided to strike that balance compared to other countries? And
one of the things most people miss is when they wrote the Constitution, no one was yet thinking about the judiciary as an important interpreter of the Constitution at all, right? I mean, we'd lived in a constitutional system. All the battles that led to the American Revolution were constitutional, and nobody thought to say, I think that tax by Parliament is unconstitutional, so let's go to court, right? It just wasn't even imagined at that time. And so the courts kind of emerged accidentally as a role player here, which is one reason our Constitution is structured the way it is.
So Larry, when I grew up in Nebraska, the impeach Earl Warren signs were about as common as the Purina pig chow signs. For our younger listeners, Earl Warren was the Chief Justice, who was really the force behind the Brown versus Board of Education that desegregated America's schools. That case raises, in my mind, a lot of issues. First of all, what is the Supreme Court doing? I mean, are we really supposed to believe that, in 1920 the Constitution mean one thing and in 1950 another? And should they have been more worried about the reaction of the majority of people? I mean, President Eisenhower, who appointed Earl Warren, certainly seemed to think that.
Right. Well, you want them to, right? I mean, you need that. The Constitution isn't fixed in time, and it's got to evolve to fit the changing circumstances of the country. So, again, you have that same problem. So you want the judges to be sufficiently independent that they can think about its law-like qualities. But, the Constitution, it's not like a statute in that it has such profound political consequences.
Now, Earl Warren had never been a judge. Now we expect our Supreme Court justices to have all this judicial background. In getting the kind of people you described, don't we really want people with a little more political background too?
Yeah, the bench should have more of a mix. I mean, historically it always did. The people who were on the court would come, some from politics, from states, from national governments. Some might be judges. There'd be some academics. But, now we've pretty much gone to one model, and I think it hurts the court.
No, you see, a more abstract. Let me ask you a more abstract question. It sounds like behind the way you're thinking about this is a certain view. I'm not quite sure what to call it, but some people might think we can neatly separate the judicial sphere, the judicial power and its reach and limits, from political power and its reach and limits. That the judiciary does one thing and the political process does another thing, and there's some kind of principled divide between them. Do you agree with that or not?
Not when it comes to the Constitution, right? When it comes to ordinary law, you can think about it that way, but that's because if the judges interpret it wrong, we can change it with ordinary processes. But when you get to the Constitution, since it both sets out what the government can do, right? It defines the powers of the government. That's different from ordinary law. And since it's so difficult to change, you can't think about it as separated from politics. So it's really an inherently mixed body.
So doesn't that mean that the Supreme Court is a inherently paradoxical thing? Because it's supposed to be insulated. It's in some ways highly insulated from the political process, but it's a deep part of the political. And it's the thing it very much does, interpret the Constitution, is a essentially political thing. But why should we insulate that essentially political thing from the ordinary political process?
This is part of the accident. So imagine you want to balance accountability and independence, whether it's ordinary law or constitutional law. But they're different, right? So if you look at most of the rest of the world, in fact, the constitutional courts are separate from the regular courts so that you can balance things differently. And then if you look at the constitutions in most of the rest of the world, they do that differently. So they make their judges have limited terms, they stagger the terms, they require supermajorities to put people on the bench. And that way you can make the judges independent, but they're kept accountable because of the regular turnover. We have none of that because nobody was thinking about this role for the judiciary, and so we've mixed everything up, and that's what makes it so hard in this country.
So it sounds like you think that in this case, as in perhaps other things, America could actually learn something from the way other countries do things.
Oh, absolutely. I think if we could start from scratch, you'd want to restructure the judiciary along the lines of the European constitutions.
Well, that's a pretty controversial thing. I'm going to take that up a bit after our break. You're listening to Philosophy Talk. Our subject today is the judiciary and a democracy. Our guest is Larry Kramer, Dean of the Stanford Law School.
We've been asking why there should be an independent or unaccountable judiciary at all. Next, we'll look at the tension between judicial power power and political power. You can join us by calling toll-free at 1-800-525-9917. I'll repeat, 1-800-525-9917.
Has the judiciary usurped politics? Plus your calls and emails when Philosophy Talk continues.
And Mr. Judge, what can the charges be? If there's been trouble, I will plead not guilty. It must be someone else. You know it can't be me.
Why, Noni Harris, and good morning, Judge. This is Philosophy Talk, and I'm John Perry.
And I'm Ken Taylor. Our topic today, the judiciary in a democracy. Have you ever wanted to hang a judge, impeach a judge? Has the Supreme Court done things that just drive you crazy? Tell us your thoughts.
Call us toll-free at 1-800-525-9917. That's 1-800-525-9917. And Al Gore, if you call, identify yourself, we'll let you right through. You can also email us at comments@philosophytalk.org.
Our guest is Larry Kramer, Dean of the Stanford Law School. Larry, in my lifetime, just as I was born, Brown versus Board of Education, the Miranda stuff, the Warren's Court, the changing police procedures, the abortion decision. The Supreme Court has become a really big deal, a really huge big deal, and with causing all kinds of social and political turmoil. Doesn't that suggest to me maybe the court shouldn't be quite in the business that it's been in during my lifetime, because it's this political thing, but it's unaccountable, and it causes all this turmoil in our politics. What do you think?
Well, I think it's okay for the court to have us say. I mean, what's really changed over the course of your life and mine is the size of the court's say has grown as we've sort of been sold on this idea that when it comes to the Constitution, the Supreme Court is supposed to speak for all of us. We're not supposed to have views. If we disagree with what they say, we're supposed to try and persuade them to change their mind or put different justices on, which is why over the last 20 years or so, we've seen the battles for appointments become so huge. That wasn't traditionally the case because the court didn't have quite the same central role.
Well, in the Roe versus Wade case and in the Gore versus Bush case, it seems to me, as not a lawyer, that the court was really usurping states' rights. Now, states' rights are traditionally associated with kind of backwards things like segregation. But in these cases, it's not so clear to me that the federal government, through the court, had any real business in saying that the states weren't legitimate choosers of what the abortion law should be, or that the Florida courts were somehow less able than the Supreme Court to decide what was right and wrong. Do you have any thoughts about that?
Well, the idea of states' rights is a little misleading. I mean, they're arguably usurping political authority, right? Saying that something that should be decided in the ordinary political sphere is in fact decided by law and therefore outside that sphere. Whether it's states' rights or federal rights, I think is actually a bit misleading in the discussion. But, again, it's one thing to say, well, those are two, you gave two huge examples. I'm not each of them could be the object of 10 shows.
Take your time. Give us 15 seconds on each.
Yes, no. Let's just take Bush v. Gore for one sec, which is what's interesting about it is to think that pretty much the same thing happened in 1876. Almost identical. And at that time, even though some people did talk about maybe the court should decide this, they wanted nothing to do with it. They wouldn't have dreamed of stepping in because had they tried to do so, the 49.9% of the country that disagreed would not have permitted it. And what had changed in that century was the notion that now not only could they, but when they did, Al Gore comes out the next day and says it would be unpatriotic for anybody to do anything other than submit to the court's resolution of core political
Tell me
issue.
a little bit about how this happened. How 1876 versus 2000. I mean, that's a huge sea change.
Yeah.
I mean, how did this happen?
Well, some of it is philosophical. I think, first the idea of democracy changes after World War II, and it goes from a sphere to think about values to, pluralism, Dahl, Schumpeter's, a place where interests fight out their selfish desires, and that blends down. And then the Warren Court comes along, and the left, which had always been sort of the force opposing the court, flips and begins to support it. And suddenly the left and right, who disagree about almost everything, agree only on the idea that maybe the Supreme Court should tell us what the Constitution means. And that eventually, becomes the popular political culture.
So the idea that I learned in high school civics is that the founding fathers were very wise, and they had this division of powers, the separation of powers, and they thought of the court as a bulwark against tyranny and usurpation. Are you telling me that idea really wasn't very well worked out in their heads?
Yes, that idea wasn't worked out at all in their heads. I mean, again, some people had begun to think about the courts as having a role here, but when they thought about judicial independence, they were thinking about the traditional English practice, which was, the king stepping in individual criminal cases to put somebody away, and just not thinking about constitutional interpretation at all. I mean, that just, and that emerges really slowly.
Was that because they thought the Constitution wouldn't need much interpretation, or what?
No, because authority to decide what the Constitution mean had to rest with that's the title of the book, the people themselves.
Yeah. We've got a caller, Ulysses in Emeryville. Welcome to Philosophy Talk, Ulysses.
Yes, welcome to the august scholars on Philosophy Talk, and to Dean Kramer. And we look forward to his spring noon lunches lecture series at Lake Lagunitas. Quick comment, and now that's a joke. We're supposed to be laughing.
I was thinking, oh my God, what did I agree to do that I don't remember?
Quick comment and a quick question with respect to the approach the judge brings, philosophical approach the judge brings to ruling prior to even reading the facts or analyzing the case. For example, the different judicial philosophies of Harlan and Holmes, whereas Harlan, who had suffered a long month of freezing at Valley Forge because the respective states wouldn't contribute enough for uniforms and materials, believed in a powerful federal government, but he also believed in individual entrepreneurship, whereas
Now, Ulysses, we want judges to be slow and deliberate, but we want our callers to be quick.
All right,
let's get to the point.
What's your question, guy?
Okay, 5 of 9 of the current Supreme Court justices are members of the Federalist Society, and the Bush administration is using as a requirement membership in the society for appointment to the federal bench. How does Dean Kramer feel that these Federalist Society Supreme Court justices will affect their future rulings of the court? And I'll take my answer.
Thanks, Ulysses.
Thank you.
Well, look, all presidents from the beginning have always taken, politics and the likely views of the judges into account before putting them on the bench. So, there's nothing new or surprising about that. Again, the only thing that's changed is once they decide that's it for the rest of us, now you have to worry a little more about who goes on. So wouldn't be opposed to the idea of taking judges' views into account when you put them on the bench, and I think that ought to be an open political process. I think the mistake is when the president gets to do it and the Senate says, but we can't inquire into what the person's views are or what they're likely to do when they're on the bench. We have to only look at whether they are smart and had a good record in law school. That doesn't make much sense.
Join our discussion. 1-800-525-9917. I've said that so many times and I'm forgetting it. 1-800-525-9917, or email at comments at philosophytalk.org. And John, you have an email right there, right?
Yeah, interesting email from Dwayne. And it ties into what we were thinking about a little bit ago. Some democracies have written constitutions like the U.S., and some have unwritten constitutions like the United Kingdom. Can your guest please discuss how the nature of judiciary differs in these two kinds of democracy, and what are some of the major consequences of those differences for the judiciary?
Ultimately, it tracks a little bit. The few countries that have wholly customary constitutions don't tend to have judicial review or strong bodies of judicial review. But I'm not sure. They're not inherently linked.
Mm-hmm.
That's more a historical accident than anything else. Most constitutional law is really not tied that closely to the text, as it turns out, and it evolves as a body of precedent. So I'm not sure there's an inherent connection.
Larry, we're talking about the judiciary in general, but you're an expert on the Supreme Court, and that's what holds our attention now. The Supreme Court's supposed to be interpreting the Constitution. To what extent is this just a myth? To what extent are they kind of vaguely constrained by the Constitution, and they're actually just kind of creating something anew for each generation?
Well, Okay.
It's another 15-second.
No, it's just loaded in the sense that it's all in the eye of the beholder. If you agree with what they're doing, they're interpreting. If you disagree, they're making it up. I mean, the reality of constitutional law is it's always a big body of customary law that is refracted through a text, though. Everybody is always sort of bringing their understandings to the text and then reflecting them out in the decisions, and that evolves over time.
Well, that's an abstract question, but here's a concrete question for our listeners. Should we be able to just get rid of Supreme Court justices we don't like? I mean, it's political. Their actions have deep political consequences. Maybe we should be able, like with other political actors, to throw the bums out. But Larry, I want to ask you another question.
That would go too far the other way, right?
You think that would go?
Yeah,
too
you
far?
want a balance. So as I say, the reason I like the European system is it achieves that balance pretty nicely. And we've had difficulty figuring out how, that's why it's been so much more controversial.
But let me ask you another kind of question. I don't think you said Al Gore, when the Supreme Court decided, out of what he believed was deep patriotism, bowed to the will of the court. I don't think that people at large, though, when the Supreme Court speaks, think, let's at least not the organized people at large. Let's merely bow to the will of the court, because they've really come to view the court as many anyway, have come to view the court as another political actor. And if the court decides in their favor, they're happy and want to keep it that way. And the court decides against them, they organize to try to put new judges in there to try to get the legislature to overturn or limit the court's jurisdiction. I mean, so
what do they do?
It's become
historically it's changed. Today, about all that's left, what they try and do is protest so that they can persuade the justices to change their mind, or wait for the chance to put somebody new on the court. But that's pretty much the limits and that's what judicial independence has become in this country.
They keep getting their legislator to pass laws that test the limits, and when they've got somebody new on the court, maybe they go to reinterpretation, But
it's always you're turning to the court. The notion that the other branches are co-equal interpreters, that what they do is equally authoritative and so can be equally followed, and what the court does maybe needn't be followed in quite the same way. That's been washed out of our political practices.
Last guy to really try to do something radical, I guess, was FDR when he had his court packing scheme. He didn't like the court, so he wanted to add, I guess, 3 new members, and he really got stung.
No, he didn't. He completely won.
Oh,
right?
Well.
He got exactly what he wanted, and once he got what he wanted out of the court, the plan died because it was no longer necessary. And to think that the kind of pressure that had been put on over the course of a few years by the Roosevelt administration didn't have something to do with what the court did, it would be naive.
So to just get the history right, you're saying that the threat of packing the court, as bad a publicity as that got, really got him what he wanted. The court caved?
Sure.
Okay. I think in San Francisco we have a pretty left-leaning audience, so I'm going to say something I hope is provocative, and I hope I'll get people to call in, 1-800-525-9917. Here's something I think. Maybe Roe v. Wade, for example, was rightly constitutionally decided. I'm not sure about that, but maybe it was. But it seems to me that here's a place where, let's engage in a little counterfactual, a little hypothetical. What if the court had not taken up Roe v. Wade? Where would we be now? Right. I think by now there would have been some reasonable compromise worked out through the political system. And that reasonable compromise, some places abortion would have been more restricted, some places less. I doubt it would be. There might be a few places where it was totally prohibited, but not very many. And moreover, people would regard this as a reasonable compromise they reached through the reasonable political process. So all the heat and anger and antagonism would have been taken out of this. So it seems to me probably the court should not have decided the case. On the other hand, similar stuff happens with Brown v. Board of Education and forced busing and all that. And it seems to me the court was right to decide, even though the turmoil was even greater, probably the court was right to decide that. So it's just really tricky to me. Right, to see what the court should touch and what it should leave alone,
but that's again only because if you start with the supposition that if the court's going to step in, they have to get it right because that's going to be it, then the pressures are high for this. But if you start from the assumption that it really is the beginning of a national conversation on issues, which of course it is, that's really what you're talking about with abortion, then the pressures are down a little, and it's not quite the same thing.
Is there any way to get back to the idea that the court just is one participant in a national conversation? conversation, among others, and not a conversation stopper?
I think we're getting back to it now. I think that's what conversations like the one we're having here and that are happening all over are all about, because that's all it ultimately is.
Of course, the Gore versus Bush thing is kind of exceptional because that conversation can't really go on, right? I mean, it had to be decided. But with respect to a lot of other things, there does seem to be some kind of...
Well, Brown is a great example because, I mean, if you actually look at what happens, the court decides what it does in 54 and nothing happens, not because of what the court did. And then you get a grassroots political movement which has very little to do with the court, which grows out of sit-ins and the freedom riders and people actually thinking about other issues that emerges into the civil rights movement. You get legislation in 64 and 65, which again, very little of which can be traced to what the court did. And once you get the legislation, you begin to get action because you had political action. So the court had a role there, but not a dominant
Would that
one.
legislation have happened without the court acting?
Well, sure. Although, would it have happened right then or in quite the same way? Probably not. But the civil rights movement was not created by the Supreme Court and Brown v. the Board of Education.
Folks, you can get in on this conversation. Call us toll-free at 1-800-525-9917, 1-800-525-9917, or email us at comments@philosophytalk.org.
And I think we've got a caller on the line now, Joan in San Francisco. Welcome to Philosophy Talk, Joan. Are you there, Joan?
Oh, hi. So quick. Thanks for taking my call. You threw down the gauntlet. So I'm taking it up.
Okay.
I think the abortion issue is one of those issues where people are so emotional, it seems to be black and white, and there's no room for discussion between the people. So in this case, I think the judge does have to necessarily step in and make a decision as clearly as he can or she can, according to the law.
John, my worry about it is the first thing you said. It's so emotional. It's so fraught.
Yes.
That when the judge decides, the emotion and fraughtness doesn't go away. It's actually only increased because one person feels cheated.
Yes.
So what did the judge do? Caused political and social turmoil, right, and churning of the political system in a way that he or she is not part of, in a way. It's like an intervention from outside.
Excuse me, but what I think it is almost like a marker, and the judge makes a decision whether it's yes or no, and then there's a time where people can say, okay, I need to step back. The decision has been made. Now maybe I have a chance to think about it. And so then people can then again step forward and, okay.
Well, no, but you want to think about it this way. I mean, the issue wasn't like that in 1973. It became that way after the court stepped in. But before that, things were moving along at a pace. Some states had begun legalization. The American sort of political public's views were evolving.
Oh,
if I may say so, basically probably in 1973 you could...
I was personally swept up in that whole thing. So
sure.
I was personally, but anyway, that's not neither here nor there, but it seems to me that things were so fraught with the inability to really talk to each other that there needed to be a point where the nation needed to stop and take a collective breath, if you will, and then maybe be able to then later step in and have a sensible discussion.
John, thanks for the call.
Yeah.
You're listening to Philosophy Talk. We're discussing the judicial branch of government with Larry Kramer, its role in a democracy, from the Stanford Law School.
With respect to Roe versus Wade, I mean, I just have one empirical comment. That is, it's not so clear to me you can get abortions in many more states than you could have if it were left up to the states.
Yeah, I think the conventional view today is if the Supreme Court were to overturn Roe, within a relatively short period of time, we'd be in about the same place as we are now.
We've been talking about the real-world tensions between the judicial process and the political process. Next, we'll explore the democratic means available for constraining the powers of the judiciary.
Keeping the judiciary in check when Philosophy Talk continues.
We love the law. We sing for it. You break the law. You'll swing for it. Order in the courtroom. We love the law. Grab your habeas corpus. Order in the courtroom. We love the law. Here come the judge. We love the law.
From the old TV show Laugh-In, that was Here Come the Judge. I'm John Perry. This is Philosophy Talk, the program that questions everything
except your intelligence. I'm Ken Taylor. We're discussing the judiciary with Larry Kramer. I remember another Here Come the Judge. Here come the judge. The judge as high as a Georgia pine. You remember that one? Here come the judge. Here come the judge.
That was probably one of those Notre Dame fraternity
that was
songs.
Flip Wilson or somebody.
That was also Laugh-In.
Yeah. Larry, so look, in a democracy, the people, the main tool that the people have for holding for constraining political power run amok our elections. That's our main tool. It sounds like judicial power has run amok. What power do the people have for constraining judicial power run amok?
Right. So, on some level, ultimately, there is just the power of public opinion, which matters a lot. The justices are always acutely conscious of the limits of their authority and the need to preserve the respect of the institution. So that's there as a check, and that's why, the statement you made at the outset is true, which is they do have an eye always on where the public is. But, the more you sort of inflate their sense of their own power, the farther they're going to diverge.
I mean, so that doesn't sound like a very powerful check. I mean, really, if the president runs away, we can't. It's hard to check his political power, especially if the Congress and the president are of the same power. I mean, it seems to be really hard.
All right, let's talk.
Really
let's
hard.
talk historically for a second.
Yeah.
This problem emerges right at the beginning, by the 1790s, and they realize that there's no good check on the judiciary, but they do have a role to play. So what are we going to do? So what prior presidents and Congresses have done in the past? Jefferson abolishes a court, right? He moves some impeachment proceedings. He makes their lives miserable and threatens not to enforce their judgments. Jackson does the same. Lincoln doesn't enforce judgments. Congresses in the 19th century pack the court left and right. Teddy Roosevelt, pushes to get judicial recall of opinions and judges. FDR packs the court. So those have been the devices when things come to a head. And the idea, of course, is to keep them from coming to a head, and that's where the justices have to keep their eye on where the country is. But it only works to the extent that there's a real threat behind it.
Let me just ask a slightly different question. Earlier, one theme that's come up is that the Supreme Court really isn't just ordinary judges. It really has to be a group of wise people that have political aspects but know the law. It seems our current system assumes that all those wise people will have been lawyers and will have been judges. You had O'Connor and Scalia talking about what it means when you say if a person uses a gun, they get life in prison or whatever. And did it mean use a gun to shoot with or use a gun to prop the door open?
Yeah.
Looks like they could have used a philosopher of language on the court. There must be lots of former senators that would add immensely to the court, even though they've never been judges. Do you see anything happening to loosen up the stranglehold that former judges have on appointments to the court?
If anything, it's moving in the opposite direction, right, over the last 20, 30 years. I mean, it's become more and more the sense that you have to have prior judicial experience, that only lawyers should do it, and it's gotten much narrower in its focus.
It's really strange, though, because it's really you can see why people would want that, because they want to at least officially diminish the political agendas that get on the court. You're supposed to go on a court without a determinate political agenda. You're supposed to just be judicial restraint and all that stuff.
Well, I think it's totally predictable, right? The way judicial power expands relative to the political branches is the more we come to think that the Constitution is just ordinary law, because ordinary law is what judges do. And if it's that, then of course you have to have lawyers and judges interpreting it. And it's the loss of the sense of the Constitution is not really just ordinary law, but is something bigger that.
But if it's not ordinary law, and if it's deeply political, so in some ways, your view of the Constitution is that the process for adjudicating what it says is somehow, it has to be essentially political. And if we try to squeeze the politics out of it, that's just some kind of pretense or something.
But it's also legal. It's really a mix. That's why it's so interesting and complicated. It has law-like qualities. You want people to understand and treat it as such, but you also want them to have an eye on the larger picture and to have a statesman-like sense of it, and to, of course, understand that ultimately it's a bizarre idea to say we're a democracy and here's the most important part of our law, and it's so important that we can't let the people have anything to do with it, right?
Yeah.
That's a very peculiar.
Yeah, that's why,
Yeah, we've got an email here that's directly on our topic of what tools do we citizens have for constraining judicial power run amok. It's rather cynical. The only democratic institution, Alex writes, in the federal system is the House of Representatives. The democratic aspect of the Senate is attenuated by the 6-year term. And I would also interject by the fact that the Senate's completely undemocratic.
In its apportionment.
And that the courts, by the life term, subject to good behavior and impeachment. But the people as a whole have no governmental power except through the ballot, and the ballot is for sale to the highest bidder usually. Oh, that's kind of depressing.
No, but again, look, we don't want to do this by referendum, right? We don't want to do laws generally, and we certainly don't want to do the Constitution. So it's not as though more democratic is better. The genius of our system, and this is what the founders were about, was recognizing that we would create a complex system with multiple institutions, all accountable in different ways, and the accumulation of views through that is what makes us feel comfortable. So the judiciary is one branch among many, and as long as it's that, the system can work.
We have a caller on something like this topic. Ide in Berkeley. Welcome to Philosophy Talk, Ide.
Morning. In the mind of many people, no question that the Supreme Court erred in the election 2000. And in my own experience, when I had a case against a Japanese manufacturer for price fixing, the judge in the case, federal judge in San Francisco, no longer alive, made a lot of errors in the trial, which pretty much destroyed my case against the company.
All right, I thought you were going to ask us about lifetime appointments.
Well, this is it. The federal judges have lifetime appointments. What can we do to keep that from happening? To put limits, and in fact to recall federal judges that do not live up to expectation and honor. What can we do?
You believe that we should have such a system. Larry, do you agree with that?
Well, yeah. I mean, I actually don't think anybody writing a constitution today would put in lifetime tenure. You would have term limits. You would stagger the terms, something like that. You might have an age limit, although I favor limited staggered terms. But, at this point, the only way you can change that in this country is you have to amend the Constitution, and that's a difficult process.
So Larry, if you could bring two ideas from other governments and just by fiat change our system, what would those two ideas be?
I think I'd just get limited staggered terms for justices of the Supreme Court would be one, and I only get two?
As many as you like.
A second would be, I think I would modify the amendability a little and make it a little easier to, the original amendment process was not as difficult as it's become. Once you have 50 states, the numbers all become
and Jefferson had this idea that the Constitution would be written every 50 or 60 years.
I think that goes, again, a little far in the other direction.
I agree.
And I would, we have the filibuster. I would formally require a supermajority in Congress so that you cannot get on the bench unless you have appeal on both sides of the aisle. I think that actually, along with the limited staggered terms, would be the key, those two things.
So, what would number 3 be?
Well, that's if I had to, I would think about modifying the amendment provisions, which are just altogether too.
So you
difficult.
would make it really easy or moderately easy to amend the
Constitution? Moderate. Again, the original balance was not bad, and so it's become much, much too difficult. But I don't think you want to make it into ordinary legislation.
I mean, people are fond of thinking of the American system, especially the separation of powers, as true genius, as a creation of true genius. You don't sound like you believe that.
Look, here's the
I mean, there are people. I got to tell you, your former colleague,
Yeah.
Your current colleague, former dean. We had her on our show on separation of powers. She loves the court. She thinks the court is the hero of American democracy.
Yeah. Well, I like the court.
You like it, but you don't love it.
In terms of the Constitution, one of the interesting things is everything the Founding Fathers thought in the 1780s when they wrote that Constitution, they learned themselves in the 1790s was wrong. Every single major premise, but they were smart enough to adapt, and we've been doing that ever since. So it's not that the Constitution is genius, it's that the American political system has been flexible and robust enough to deal with the flaws as we went along.
Well, it's interesting that our Constitution, our democracy, may have been the first of any size and importance in the world, but most of the ones that have come later have had a parliamentary system rather than our system and have had a different way of dealing with the courts.
Plus, our system collapsed. I mean, the Civil War was the American system, boom, just collapsing in on itself.
Two separate things. So it's true, although, there's only so much you can do with structure, and there are going to be some issues that no matter what structure you come up with are going to break the country apart. That was slavery. The really interesting thing is how once that issue was resolved, how quickly things got back on track because of the inherent strength of the system. And the world is actually more divided between presidential and parliamentary systems. The Europeans have gone the parliamentary direction. The South Americans have gone the presidential election. So again, there's a mix.
Which is more of an island of stability, South America or Europe?
Okay, fair enough. Fair enough.
But Larry, this has been a great discussion. Obviously, we've just scratched the surface. This is profound stuff, and you've helped us a lot to clear it up. Thanks for joining us.
It's been great fun.
Our guest has been Larry Kramer. He's the Richard E. Lang Professor of Law and Dean of the Stanford Law School. He's author of The People Themselves, Popular Constitutionalism and Judicial Review.
We couldn't get to all our callers. We have a couple of really interesting emails we didn't get to. Thanks a lot for calling and emailing. It helps us to know that we're being listened to, even if we don't get a chance to talk to you.
I was disappointed a few more callers didn't take up the gauntlet. I assume we probably have a lot of lefty friends of like the Warren Court and the Roe v. Wade, and we were kind of trashing that stuff today.
Well, I think it's because between the three of us, we represented such a diversity of intelligent views, there wasn't much more to say.
So what did you learn today?
You're on the left, not clear the court's your good friend too.
Yeah. What did you learn today, John?
Well, what I learned today is that some of my own prejudices and half-baked thoughts are supportable by people that actually know what they're talking about. I have a very good feeling. I learned that you can have programs with deans of the Stanford Law School and former deans of the Stanford Law School, and they're not exactly the same. That even at these high reaches of legal expertise, there's real differences of opinion.
Kathleen, I recommend people go back and listen to our show on the separation of powers with Kathleen Sullivan, and this show kind of in tandem, because Kathleen had this really worshipful attitude toward the court and its role in American democracy. She thought it's the vanguard against tyranny and the protection of liberty, and its interventions have been mostly wise. I've become less and less convinced of that. I really think that if the court had left some of these things alone, over the long term, we would have been better off.
Well, I must admit that in reading up for this show, I reviewed some things about Bush versus Gore, and I got upset all over again.
Yeah. So, but like I said, we started a blog. I started a blog. This conversation will go on. It's a really complex question. On the other hand, I said sometimes the court stepped in to our peril, but sometimes it stepped into our good. I mean, it was really right. Brown v. Board of Education, that was really right, despite the social turmoil.
Well, and it required some courage, although I guess the Miranda stuff that came later was really what made Warren so unpopular. During one of the breaks, our guest informed me that I was a little off base on that. The court ought to have great courage, but it shouldn't be absolutely bonkers.
So we really need wise people on that court. Anyway, folks, this conversation continues, as always, on our blog, theblog.philosophytalk.org, where our motto is Cogito ergo blogo. I think, therefore, I blog, and I've already started the conversation.
You can download podcasts of our program from our website as well. Now, for the final word on all of this, we turn to a man with a judicial philosophy all of his own. Our great, unmatchable Ian Scholes, the one and only 60-second philosopher.
Ian Scholes. I'd never heard of stare decisis until John Roberts was nominated for the Supreme Court. Then every reporter and pundit in the world suddenly wanted to know where he stood on it. Well, I discovered that stare decisis is Latin for stand by things decided. In other words, stand by precedent. Stare decisis is a controversial concept. Why stand by precedent, critics want to know, if the precedent is bad? What if the precedent is based on concepts not found in the Constitution? That's what Supreme Court judges are sworn to uphold, after all, not precedents. So the queries about stare decisis were a coded way of asking Judge Roberts what he was going to do about Roe versus Wade. The Supreme Court could do without stare decisis and make out just fine, but where would Judge Judy, say, be without it? If Kimberly comes before Judge Judy suing her former roommate Sean because he made the birthday cookies too big, is Judge Judy going to go to the Constitution to make her decision? No. Unless it says, Congress shall make no law abridging the right to make large cookies. Judge Judy is going to eyeball Kimberly's mouth, eyeball the cookies, and make her decision based on that. Future judges, should they have to face a similar cookie crisis, will simply review tapes of the Judge Judy show and base their decisions on that. Stare decisis in action. Stare decisis has its roots in common law, which was codified by Henry II when he became king. Back in the 12th century, he decided something needed to be done about England's chaotic justice system. At that time, all justice was local. There were no national laws or consistent punishments. Catch a thief in one village, he might get a wrist slap. In another, his hand cut off at the wrist. So King Henry sent judges out into the boondocks to resolve cases based on local customs, then returned to London and wrote down why they ruled as they did. These decisions were read by other judges. In time, it became the rule that if a case is similar to a previous case, the judge must follow the interpretation of the previous judge. So now everybody was on the same page, an overlong, overcomplicated page, but the same one. Law-wise, Henry II was more famous for his feud with the Archbishop of Canterbury, his former friend Sir Thomas More. This feud was based on Henry's desire to have clergy, should they be accused of a crime, tried under the king's law and not the church's. The archbishop, once the king's ally, now the church's, would not yield on this. After years of dispute, the king vented before witnesses, "Will no one rid me of this troublesome priest?" And foreign knights obliged by stabbing the archbishop to death at the cathedral in Canterbury. The king was never put on trial for his alleged role in this murder. Kings seldom are. But because of the resulting bad PR, he had to let his quarrel with the church go. There's a long history of leaders getting rid of their enemies through foul play. Just in this century, for instance, Russian President Vladimir Putin is suspected of doing in various former spies, businessmen, and journalists who don't approve of him. Could it be said that this type of crime is a kind of stare decisis in reverse, practiced by criminals instead of judges? There are many precedents, after all. What would Judge Judy say? I gotta go.
Ian Shows, the only man who can solve a philosophical problem in 60 seconds.
Philosophy Talk is a presentation of Ben Manella Productions and the trustees of Leland, Stanford Junior University, copyright 2007.
Our executive producer is David Demarest.
Special thanks go to Devin Strolovich, Neil Van Leeuwen, Zoe Corneli, and Mark Stone. Our senior consulting producer is Gordon Earl.
Support for Philosophy Talk comes from various groups at Stanford University.
Also from the Friends of Philosophy Talk and the members of KALW Local Public Radio San Francisco, where our program originates.
The views expressed or misexpressed on this program do not necessarily represent the opinions of Stanford University or of our other funders.
The conversation continues on our website, www.philosophytalk.org. I'm John Perry.
And I'm Ken Taylor. Thank you for listening.
And thank you for thinking.